When we're talking about custody, we're talking about where's the child going to live and who's going to make decisions. Those are the two areas that we're talking about. The first, of course, is very basic. Where are they going to live? And that's what a lot of people fight about because it's where they're going to live primarily. So, where are they going to live during the school week? Where are they going to be on the weekends? So for years and years and years, it was whoever got the child during the week, the other person would get every other weekend, typically the father. A lot of things have changed in the almost 30 years that I've been doing this. It used to be, why should the non-custodial parent get more time? Now the question is, why shouldn't they get equal time? So you're going to approach your case in that regard, and you're going to have to look at things like, who was there every day? Who made the decisions day to day? Who booked the school meetings? Who booked the doctors? Who attended the doctors? Who arranges the child's social calendar? Who is doing all of that? And the court's going to look at this and say that may be the person that should be the primary residential custodian. So how do you fight that? You fight that by documenting. Documenting the time that you attended those appointments, attended the school meetings. What does your work schedule look like? Are you actually able to do this on a day-to-day basis? Because the courts see it as preferential for the party to be with a parent rather than with daycare or aftercare. So schedule plays a huge role in this. The second part of this is who's going to make the day-to-day decisions. Now, 3 areas of decision-making are what we're discussing. 2 really are more important than the third. Healthcare decisions and educational decisions. And the third is religion. So the healthcare decisions and the educational decisions are paramount. And the parties ask themselves, and we ask them, are you really going to disagree on healthcare decisions? And that happens sometimes. Maybe some person doesn't believe in public education, they believe in private education. Maybe a person believes in alternative medicine rather than traditional medicine. Very often these questions come up when a child is being prescribed ADHD medicine or vaccines, and the parties have very differentiating views, and they'll wind up in court. So there's several ways you can resolve custody. So you can do it by agreement, or you can have a court order. Or you can have agreement that's made into a court order. And what the parties ask themselves is, can we truly have joint custody when it comes to decision making? That's the question that's asked. And do we have to set up a framework for what happens when we don't agree? Meaning, if after discussing everything openly and having access to records and discussing this with doctors and experts, do we give one person the final decision-making stay if we disagree? If not, you're going to head to trial, you're going to have a custody trial, and the court's going to typically pick one person to have sole custody. And what sole custody means when the court uses that term is who's going to make the decisions. Does sole custody give that person the right to pick up that child and just move? Leave New York, leave whatever state you're in and go to another. And the resounding answer to that is no. Because you have sole custody does not mean you could pick yourself and that child up and leave. You're going to need that other party's consent or a court order, because leaving means you're destroying the relationship with the non-custodial parent. So don't make that mistake. Don't assume because you have sole custody that you can just relocate. Best interest of the child. This is the standard the court uses when making a custody determination. And what does it mean? It means the judge just gets to decide who they think is best for the child to make decisions and to live with. So all things come into play. And there really is no checklist for what the court has to follow. Best interest of the child is just such a big umbrella. So what does the court look at? They look at who's involved most, who is involved on a day-to-day basis. Does one party engage in dangerous activities with the child? The most important thing a party can do to prove that they are a better custodial parent is to foster the relationship with that child with the non-custodial parent. Don't speak poorly about that party. Don't gaslight the other party. Don't engage in parental alienation. And what is parental alienation? It's not just speaking badly about the non-custodial parent. It's doing things like questioning the child when they come back from visitation. Saying things like, oh, did you miss me while you were away? I couldn't stop thinking about you. Did you have a good time? Oh, were you sad? Were you alone? Were you left alone? Oh, I don't think it's great that they did that with you. Those are the kind of subtle things that alienate the relationship with the other party, and the kind of things that would ruin a person's case to prove that they're the proper custodial parent. So again, best interest of the child is a very big umbrella and gives the court a great degree of latitude to make a decision. Changing custody orders. there's two ways. First, a party has to show what has changed, what circumstances have changed since the last time there was an order. And a lot of things can come into play. Change of schedule. Maybe the party who's the non-custodial parent suddenly is available much more frequently. And now, where they couldn't see the child during the week, now maybe they can. Maybe they work now a part-time schedule. Maybe they're working at home. Most often what happens for a change of custody application is something happened with that child under the custodial parent's care. It could be something physical. It could be an injury. It could be alienation. It could be many things. But something would have to have changed. Very often what happens is the child reaches a certain age and starts expressing preferences. The next question is, what is that age? And I get that question all the time. How old does my child have to be before they say, I want to live with you? I want to live with dad now. I want to live with mom now. There isn't a bright line test in the law that says if they reach, say, 15, they can call their own shots. And different judges see it different ways. But usually by the time they're starting to hit high school or late middle school, their opinion carries much more weight under the law and must be given much more weight. Can you move your child after divorce? So this question goes to the party that has primary residential custody or sole custody. Can you relocate? The answer is no, not without an order of the court or consent from the other party. And why is that? I get this question a lot from clients. I have sole custody. I'm going to move to Florida. I'm going to move to North Carolina. I'm going to move somewhere where it's cheaper. The answer is by doing so, you would decimate the relationship with the other party. And that's why you don't have the right to just pick up and leave. So what do you have to do? First, get consent. If you notify the other party that is your intention to leave, and what do they think about it? If they consent, of course, you can go, but don't make the mistake of not putting this in writing, either through an amendment to your stipulation of settlement or putting together an agreement and seeking the court to ratify it or so ordering the agreement. And the other way is to make an application to the court. You do so by making an application in the same action that you had, or going to a different court. In New York, we have both Supreme Court and Family Court, seeking a relocation application. And what goes into that? You have to prove many things. But again, it's that best interest test. Is it in the best interest of the child to relocate, not the parent? Things like, are the schools better? Is there more support? Is the non-custodial parent keeping up with their obligations? Are they actually visiting with the child? Are they current with their support? If they're not visiting or paying support, it's going to tremendously help your case. If you're able to go somewhere where you have an easier job, making more money, cheaper cost of living, and say you have family supporting you, that helps your application. But it is a tough application to prove if the non-custodial parent is regularly visiting and keeping up with their support obligations. If you have questions about custody and you're in New York, call us at the Sklavos Law Group.